This should be information that underlines what we need to do to move this country forward. Well, hello, everybody. It's David Leis, your proud host of Leaders on the Frontier. This is the live edition as we do this every Thursday, and we talk about important issues for all Canadians, but from a particular lens, a policy lens. And we are delighted that you could join us on June the 11th, 2026, the year of our Lord. So a warm welcome. We're glad that you can join us. The courts in our country are very important. They're part of our governance system. You recall that we have, of course, many different pillars of how we govern this country, whether it's the executive branch, the legislative branch, but also our media, and of course, our justice system, including the important leaders in the judicial branch named judges. So judges are important to our society. And so we're going to dive into that. We've got the A team on our panel today, and we're going to examine this topic and have a frank discussion. So stay tuned. We welcome your comments, and we get them by the thousands. And speaking of comments, I want to thank you for them. And so we want to dive into every number of these comments. Every Canadian should listen to this. Thank you. And that's from L. Vanderkemp. And thank you for having Mr. Redmond, that's Colonel David Redmond, on as your guest. I've not seen him before. Very knowledgeable man. Maybe he should be Canada's next PM and get us whipped into shape. And that's from Marilyn McCall. Thank you, Marilyn. That refers to a conversation that was released this Tuesday, the long-form interview about Canada's national security system. And you'll see that Colonel Redmond did a quite an in-depth analysis about this, given his some 27 years in national security matters. And I think you'll find that quite an eye-opener. And how does that relate to prosperity in this country? Other comments. I want to reach across a screen and shake this man's hand. I've been mumbling the very same things all along, and he has laid it out so precise and accurate. Great interview. And that's from Elastic, I believe it's pronounced. Lieutenant Colonel David Redmond for PM. This gentleman has the most realistic analysis of the status of the Canadian dysfunction and what is necessary for reviving Canada's national success. He clearly understands Canada's national interests, and that's from Boss Bullmark. Thank you very much. So keep those comments coming. We really appreciate it. And as people come on, I want to highlight some headlines across the country. There's so much going on. That would be an understatement. And ironically, for this topic today, the Chief Justice Wagner warns against, quote, attacks against courts and judges. And that was a headline. Wagner also applauded unnamed Chief Justice who recently spoke out after critical comments from a politician. So we'll talk about that a little bit later, but that's interesting from the Chief Justice as they sent some comments. In Winnipeg, Kevin Klein, the publisher of the Winnipeg Sun, who we feature a number of columns in, said the Human Rights Museum in Winnipeg is treating Jewish concerns as an afterthought. And I believe there's some parties that are suing the museum. The museum has remained largely silent in the face of widespread opposition to its upcoming displays and exhibits. So this is quite a discussion about that museum. What do you think? The Carney government has announced a ban on social media for kids younger than 16, but it will allow exemptions. It's a complex topic. What do you think? Will that work? Other comments, the Bank of Canada keeps its key interest rate at 2.25% as it tries to balance competing economic risks and recognizes the challenges of the Canadian economy. We also have some criticism regarding the accuracy of so-called financial figures relating to the deficit. Finance Minister François-Philippe Champagne misled Canadians on the size of his near-record 2025 deficit, and that's according to the Budget Office figures disclosed yesterday. And this came out in the Blacklock's Reporter, I think an outstanding source of news, because this is all original documents from, well, the government itself. Analysts also talked about the upcoming efforts to build a pipeline to the coasts As Cenovus has ripped Canada's oil pipeline plan as unfinanceable. And that's from one of the leaders in the industry. They've said that the regulatory barriers are just too steep and basically makes and undermines the business case. And that's from CEO John McKenzie. And he said this on Tuesday. Also, I wanted to highlight a interesting poll that, according to this one, and this is from 338canada.ca, that many Canadians want artificial intelligence to be regulated. We know that AI is a powerful tool, but it's often misused or not understood or simply not accurate. So this is an interesting poll. What does that mean? And I wanted to highlight an interesting article by our guest coming on here, and that's by the Honorable Brian Giesbrecht, former judge. And this is an article that was featured recently in the Western Standard. Who owns Alberta? The Indians, as Chief Trevor McCready and other First Nation leaders challenge Alberta's independence debate. Race-based collective rights are undermining equality, property rights, and national unity. What do you think about that? I also want to mention that today, Frontier is releasing its annual edition, the Demographia International Housing Affordability Index. This is done with Chapman University and the Frontier Center. And of course, the lead researcher on this is the great Wendell Cox. So stay tuned. Be sure to look at our website as that's released today. And that's a very significant world index as it talks about housing affordability, including in Canada. And be sure to look at that, and we'll be discussing that again. So let's talk about our topic today, and that relates to the role of judges. We know that judges are very important, and I wanted to commend our guests. I want to welcome former Judge Brian Giesbrecht. He's a senior fellow at Frontier, and a warm welcome to you, Brian.
Thank you.
Brian, you have released the other week a very interesting article, and it was entitled, have judicial activism is destroying the rule of law in Canada. And you basically argue that the Canadian courts have abandoned judicial restraint for ideological activism. And this is eroding confidence in the rule of law through controversial rulings on the Emergencies Act, Indigenous claims, property rights, and the expanding judicial role in politics. And I encourage people to look at that article on the Frontier website. And I thought it was a very thoughtful, measured analysis. I mean, obviously, as a former judge, you know that judges have a very challenging role. We need good judges. That's a very important institution. So I want to ask you, Brian, why did you decide to write this important analysis?
Well, to answer what the Chief Justice Wagner said about attacking courts and attacking judges, I'm certainly not doing that.
Mm-hmm.
I'm not attacking the qualifications of any of the fine people who are being appointed to the bench. What I have said in that article is that we once had a balance, a better balance in this country of, if you can call them small c conservative thinkers and liberal or progressive thinkers. And I think that has been largely upset in this last 10 years. Leaders like Stephen Harper and Jean Chrétien, I believe, recognize the need to have a balance of these two types of thinkers. And I believe what's happened during the Justin Trudeau years is that the progressives really dominate on the court now.
Mm-hmm.
I use that example, David, because I think it's such a clear example of the parental rights issue, where a parent can find out that their child is displaying transgender characteristics at school. And to the conservative parent, small c conservative I'm talking about, they would want to know right away if their boy was starting to identify as a girl, that type of thing. And it would be just common sense to them that they should be informed. But to the progressive thinker, That's not the case. If the child is saying, "Well, don't tell my parents," then they would have some sort of discussion with social workers and teachers, and a parent might actually find out half a year into school that their child had been called by a different name and was even wearing clothing, of the other sex. So it's a very serious issue. But I use that example because in the provinces, at least the Western provinces, the percentage of parents who would want to be informed, who would just assume that they would be informed immediately, is overwhelming. It's about 85%. But most of the judges, or at least many of the judges, would rule the other way. In other words, it's a clear example of where the courts are not representative of the general population. So that's the example I use in my in my paper. So I'm not saying anything radical here. I don't think. I'm saying that there has to be a move towards a better balance of progressives and conservatives on the court, including on the top court, on the Supreme Court. Yeah.
Okay. So, well, I certainly recommend people read your article, Judge Brian Giesbrecht. It's a fine analysis because you're making the point that there's a philosophy of law here that begs the question to what extent it reflects kind of the general norms and perspectives of the Canadian population. I mean, you served for many years on Queen's bench or King's bench, pardon me now, and you saw this. And why does that matter that your decisions had some type of reflection with larger society, Brian?
I'll correct you there. I was on the provincial court.
Pardon me, the provincial court.
Yeah, that's fine. Well, I think it matters an awful lot. Think of some other examples. Think of the example of a person being sentenced. Well, the conservative thinker, and I am and was one of those, would say that the sentence you receive should depend on the crime you committed and on the circumstances of the offender, but it should not. It should not depend on what race you are. That should be irrelevant. But again, the progressive thinker would say, well, we have too many Indigenous people in jail, so that means we should sentence people differently. So there's another example. And the conservative judge would say, in the case of a person who has committed a serious offense, well, this person should be penalized and should be in custody, whereas the progressive judge might be inclined to say, well, no, this person should be released. So it makes a huge difference to the average person. But overall, I'll see what Leighton and Marco think about this, though. I think the progressive judge is inclined to say the role of the judge, the role of the court is a very large one, and the court should be intervening in many situations where the conservative judge would say, no, the court's job is to interpret law. The court's job is not to make law. So that is probably overall the biggest example of where there really is a fundamental difference in the attitude of the two. So my overall argument is we have to have a balance of progressive thinkers and conservative thinkers.
Okay, so well said. It's interesting. There's a lot of comments from our audience already. Arctic Hero says, Western civilization is circling the drain. The judiciary is ideologically co-opted, compromised, and corrupted. And it strikes me that kind of comment, Brian, goes to your point that there's a lot at stake here, because if the courts, the judges, their approach to judicial decision making are off or not really in alignment with society, you risk losing credibility with the institution, and that's very concerning, is it not?
Oh, I think so, and of course the Chief Justice has commented on the fact that the courts and judges are in fact being being attacked, but the response would be probably, well, let's take a look at what the courts are doing. As you know, David, I've been very critical about the Cowichan type of decision, and that, of course, is based on Supreme Court decisions made some time ago, Delgamuc and Silcotin, etc.
These are the land decisions in
These
Richmond,
are the
BC.
land decisions, and I've written many articles on this. I'm saying that the court vastly overextended itself there and went far beyond what they should be doing. And again, that means that the court is inviting criticism. Once people find out that even basic property ownership and home ownership is affected, then I don't think the courts can expect that they're going to be insulated from legitimate criticism. So yes, this is a very important topic, and I understand and agree completely with the Chief Justice when he says, well, we have to maintain the integrity of the courts. But I believe that the courts are going to have to start looking a little inward at the decisions that they're making, and the Indigenous land issue is probably the single biggest issue on people's minds, at least in British Columbia these days.
Indeed. So well said, Judge Brian Giesbrecht, retired. So I want to turn to the outline of the show here just before I introduce our two other dynamic panel members. We're going to cover a lot. Courts and judges, are they political? What's the impact on Canadians and why this matters to our society? And then what are some of the solutions? So on that note, that's our mini agenda here. It's a big agenda. I want to introduce lawyer Leighton Grey. He's a constitutional lawyer. He's practicing, and I know that he was considered as a judge. He's at Grey Woke Spencer in Cold Lake and Calgary. So a warm welcome to you, Leighton.
Yeah, it's great to be on the show. Thanks, David.
And he's also the host of Grey Matter, and he's a senior fellow at Frontier and good friend. And then, of course, our dynamic Dr. Marco Navarro-Genie, the Vice President of Research at Frontier. And welcome back. And he's a very familiar face on the show here. So great to see you, Marco.
Thank you. Thank you.
All right. So I want to turn to you, Leighton. First, do you agree with Judge Brian Giesbrecht's thesis that, golly, the judges are becoming perhaps a bit too political in this country, as we just discussed?
Well, Brian is right, as he usually is on these types of topics. But I think that the problem is even deeper than what he's saying in terms of having a conservative versus a progressive or liberal on the court. The problem is endemic. And I go back to something that Baron Denning said, one of the great British judges of the 20th century. He said that the keystone of the rule of law has been the independence of judges. And it's only the respect in which we can make any real separation of powers. And that comment was echoed by one of the great judges of our Supreme Court in the 20th century, Justice Bora Laskin,
yes,
former
indeed.
chief judge. When he was outgoing in 1982, he said he phrased the independence of judges as complete abstention from political commentary. And that was the standard before the charter. Well, enter the Constitution Act and the charter, a different era. And there's a great book by a man named Michael Wagner, who is an Alberta historian. You might have had him on your show. Maybe the best book that's been written on the charter. It's called Leaving God Behind. The thesis of that book, with which I quite agree, is this: that prior to 1982, what we had in Canada was a system of government where Parliament and our legislatures were supreme. And that meant that we had representative democracy because, if we didn't like the type of government we were getting from our elected representatives, we could vote them out. Well, in 1982, something very subtle was done, and that is judges were given this power to actually strike down laws. And what they've done is they've weaponized that power, in my view, and I think this is supported by the Section 35 decisions and many others. In fact, many of the laws that Canadians are suffering under right now, they would be shocked to learn, do not come from our legislatures. They actually come from activist judges. And so the situation in Canada now is that we've had this sort of silent transference of political power, of lawmaking power, to the judiciary. And I think, honestly, they're sort of puffed up and sort of drunk with this power, to the point where, earlier this year in January, a group of judges in Alberta got together and they issued a press release criticizing our premier. And I thought this was really shocking, because these are the same judges who were stone silent about the violation of the charter freedoms of every Albertan, 4.5 million of us, throughout COVID. And yet they said they had to come out and criticize the premier in order to uphold the rule of law. So I think Brian is right that we're getting more and more progressive type people on the court. But I think the problem is endemic, that the system is actually attracting those types of people to the court. And of course, progressives see the judiciary as an arm of the executive state. And that is precisely how the judiciary seems to be behaving on the whole, with some exceptions, in Canada today.
Well, that's very helpful, Leighton, and quite an analysis. That it sounds like in 1982, that was again a seminal moment with the adoption of that part of our Constitution that gave judges that much more power. So that in itself, I think, underlines Brian's point as well. Very, very interesting. So Marco Navarro,
it does.
I think it does. So Marco Navarro-Genie, I mean, you look at this as a researcher, a policy expert, a political scientist. What is your comment about this issue and the politicization of this important role?
You won't be surprised to hear me say that I agree with the thesis that 1982 is kind of a watershed, and it constitutes a massive transfer of power from the legislature. And in our system of government, I remind people, the legislatures are supreme. And so there's a large amount of power that is transferred to the courts through the Constitution and through the Charter of Rights. Justice Lemaire at the time said that he looked forward to putting a mark on the country. And so he saw himself as an instrument of transformation of the country, and this is a judge. And so the one thing I think that we need to remind ourselves is that our system allows for judges to make decisions that, on the odd time here and there, changes the laws. This is part and parcel of the system, and is called judicial review. And so the answer to the question, are they political? I would say yes, and I would also say no, but not uniformly. And so they have the power to change certain things. The issue really is, or the other problems, is not so much that they change the laws, is that they are actively doing so, that there is a kind of a concerted effort, that the changes often don't come from law, but they come from faculty clubs, if you will. They've been taught and bred into these things through the charter. That there is the thesis put out by a couple of professors from the University of Calgary called the Court Party thesis, which essentially argues that there is a whole collective of people in the country who actively uses the courts and the judges and the charter to change legislation, so as a way to bypass the power of the legislatures. And that is, in some cases, in most cases, I would say, usurping the power of the legislature.
Okay, so Marco, can I just pause you just for
the third problem?
Can I just clarify something there, Marco?
Yeah.
So are you saying that there are special interest groups that consciously, instead of going through a Democrat process through legislatures, like working with the politicians to make change, they use the court system to drive change through, like, all kinds of lawsuits that really drive their own agenda?
Absolutely. And you see it, for example, in a number of interveners that are allowed to come into the court. They pack the courts on purpose with these people who come and argue one side, for one side, alongside the policy preference of the government, typically.
And what is an intervener? Just to clarify that, because it's a very interesting term.
An intervener is the legal name is a friend of the court. It is someone or some group of people who have a particular expertise or stake in the legal issue at hand, and they apply to come to speak to the court. We had, for example, during the Trudeau years, while there were processes, this wasn't necessarily in court, but the principle is the same. The Trudeau government invited dozens and dozens of foreign NGOs to come to participate as interveners in processes that essentially wanted to shut down pipelines in Alberta, right? And so
Amazing.
it's a political way to sort of sneak back the door all kinds of political activists into the courtrooms.
Right. So the big workaround, right? So they're making
Yeah.
government's making a big decision. They run it through the courts, and then they help fund and put at the table all kinds of voices of these special interests. So Canadians don't really have a voice in that context. It's all through the courts.
No, and what is worse is that many, if not, and often most of these people who come as to intervene in these court cases are funded by the taxpayer through a program called the Court Challenges Program. So people are paid to hire lawyers that are activists to come and argue these things and advance what essentially is typically a progressive agenda.
Wow. So we've got a lot of layers to this onion here. So I'm going to go back to Judge Brian Giesbrecht. Is what Leighton has said, that the Constitution over time has really enhanced the role of judges, and what Marco said, there's even another layer where you've got the use of governments to really enable not lawfare per se, but the use of the law to drive all kinds of agenda. Is this all making sense to you, Brian?
I've got a technical issue here, David. I can hear you just fine, but both Leighton and Marco's voices cut out at a certain point. I'm not sure, so I might be repeating some of this. But if Leighton's point is that the Constitution, 1982 changed things, well, of course, yes, a great deal. But on my pet peeve, which is on the Indian land claims, particularly, where the Supreme Court has literally invented new concepts such as Aboriginal title, duty to consult, etc. I think my reply to that would be the Supreme Court did not have to be as activist as they were. In other words, the Section 35 says that the duty of the court is to protect existing Aboriginal rights. Now, there's a long, and Leighton might have covered this, I don't know, so I apologize if he did, but there's a long history to that, where the original Section 35 wasn't even supposed to be in Pierre Trudeau's package. As a matter of fact, Pierre Trudeau had property rights protected in his original package, and then Section 35 was suddenly introduced, and at that stage, the premiers, a number of them, especially the more senior premiers like Lougheed and my province's premier Sterling Lyon, loudly objected to putting property rights. Putting Aboriginal rights in there at all, because they feared exactly what has subsequently happened. What they feared, and you can go back and look at their words, they feared that an activist court was going to basically create all sorts of new Aboriginal rights. And they refused to sign, and only when the agreement was made to put in existing, to make it very clear that those were to be rights as of 1982, and did they agree to sign. But the Supreme Court, and here's where I believe that they made huge error after 1982, then began creating a brand new Aboriginal rights. The Aboriginal rights as of 1982 were actually quite modest. The treaties are all basically the same, and I won't go through what the treaties say, but basically they gave the Indians pretty modest collective rights.
Mhm.
Collective rights consisted of what was in the treaties, basically, and that the main one was the right to hunt and fish on unoccupied Crown land until it was needed for other purposes. And then they got some other compensation. I mean, the treaties are important. I'm not trying to minimize them, but they were very modest agreements. They were certainly not the modern treaties that we're now seeing given to the people of British Columbia that have been negotiated behind closed doors for years. And so what the Supreme Court did with that Section 35, my argument is that they were far too ambitious. They should have confined their role to an examination and interpretation of the existing Aboriginal rights as of 1982, and instead have opened up a whole hornet's nest of issues. And that's what's playing out, regardless of how the Cowichan case goes eventually on appeal. It's opened up a whole hornet's nest of issues, and I believe that that is the biggest example of judicial activism, and I think that's one of the reasons why the Canadian people are quite upset. That's one of the reasons why people are, in fact, taking a look at the court and asking if their rights are being protected by this institution, or if it's the opposite. Yeah.
Okay, so there you have it. That's a key phrase that has been used today in our discussion, is judicial activism. So Leighton, would you agree that judicial activism is kind of a key centerpiece of what we're talking about today? And are there other examples that come to your mind that are of concern?
Yeah, well, there are many, and a lot of this was authored by the court over which former Chief Justice Beverly McLaughlin presided when she was the chief judge. And she once famously said, when she became chief judge, she said, between the extremes of excessive judicial activism and judicial timidity, we will find solutions that will serve Canadians well. Well, the problem is that, as Brian says, the courts have leaned heavily towards judicial activism, not very much at all towards judicial timidity. In fact, not at all. And the situation has not served Canadians very well. And the Section 35 file is an excellent example, because as we saw recently with Justice Leonard's decision in Alberta, which essentially declared unconstitutional a citizen-led petition to have a referendum question put before the people of Alberta, she said that was unconstitutional because it interfered with Section 35 of the Constitution, as Brian says. What she was essentially saying, and she was really echoing what our Supreme Court had said previously in cases like Delgamuckw and a series of other ones following, is that these treaties are not just treaties, they're actually constitutional documents. And that was never discussed at the table when Brian Peckford and company were there. Brian Peckford will tell you that now, but that's how judicial activism can shape things. And it's not just the Aboriginal file. It was the court which conjugated LGBTQ rights into human rights. It was the court that that the Supreme Court has struck down, mandatory minimum sentences for serious sex offenders and pedophiles. It's the courts that are saying that, people who have just arrived in Canada have all the same rights to our benefits, to our social welfare programs as Canadians who have been here contributing for many, many decades, and on and on and on. So what we've seen actually in the post-1982 era is a court that has spent more time creating and promulgating rights that actually aren't in the charter, that weren't part of Canadian law. They've done more of that than they have protecting the rights that are actually set out in the charter itself. And the way they've done this is because they've accepted a view, a method of judicial interpretation called the living tree. And Brian basically described it. It's this progressive idea that we're going to make the laws as we go along. We know what's best. We are the elites. We are the intelligentsia. We know what's best for Canadians. We don't care what they're telling us. We don't care about what they want our law to look like. We're gonna shape the law based upon what we think, our vision. And of course, that progressive vision is one that many Canadians reject. And I think that this disconnection between what Canadians think the law is and what they think it should be, and the laws that are actually being created and applied by our courts, that disconnection, I think, is causing deep social strife in our country.
Okay, so this is, we don't want to miss the headline here. The point you're making, Leighton, as it's been alluded to by, Judge Brian Giesbrecht and Marco Navarro-Genie, is the philosophy of the law has shifted from equality before the law, and there's, the precedent setting, the common law, if you will.
Yeah.
And that has a long, long history, right? Some thousand years.
All the way back to, for example, Lord Alfred in the 9th century,
Yeah,
who, by the way,
absolutely.
he said the rule of law is not just that no one is above the law, no one's beneath it either. And that's a big problem. And
Yeah,
that's a
that's
big
right.
problem in Canada today.
That's right. So all these jurists from Cook, Black, there's so many of them, a long history. That is being flipped on its head within the last few decades, I would say.
Yes.
Would you agree? And to a point where it's now about social justice, rather than just justice, equality before the law. It's about social justice and the desire by judges to insert themselves, create the law, this living tree philosophy, to change it so that the outcomes are equal.
Yeah. Yeah.
Is that a fair comment?
It is. It goes back to the 1960s at Harvard, and people like H.L.A. Hart and Ronald Dworkin and others who came up with this idea that the purpose of the law is to achieve social justice. And of course, that's not what people like Thomas Aquinas understood the law to be. The law is supposed to be an ordination of reason for the common good. And so we have this disconnection and this conflict between, again, what many Canadians like myself and Brian and perhaps Marco and you think the law should be, and what it actually is and what it's doing. And when, as you pointed out, when we see that disconnection, something very serious happens, and that is we lose confidence in the rule of law. We lose trust. We're a trust-based society, and when we begin to question that our lawmakers, all of them, are somehow corrupt and not acting in our best interests. And when that starts to happen, something very, very fundamental begins to be torn away from the structure of our polity.
Okay, I think we're onto something big here. If we're paying attention here, I noticed a comment from the audience. It's very interesting, the citing of Bruce Party, where we look at the comment here that says, Bruce Party has it right. Rule of law has become rule by law. And this is from Vicky Knight. Thank you, Vicky, for that comment. So just before I turn to Marco Navarro-Genie on that point, I want to just look at the bigger picture, because one of the primary questions that every society has to address or answer is, how do they self-govern? And so if we look at the bigger picture here around institutions, we've got a variety of institutions that govern our society. And I think there's a really good slide on this that we could reference. We've got, of course, Parliament, which is elected. We've got the sovereign, namely the crown, but we've got these executive branch and the legislative branch, and we've got the judiciary. And of course, the media is another important part. We've got both provincial courts and federal courts. But a key issue here is that usually there's a separation of powers. There's power needs to be checked. Otherwise, as Acton says, power needs to be, if absolute power corrupts absolutely. And so power needs to have checks. In our system, we don't quite have that, because we have a legislative system, Marco, where we have the legislature. But if the persons in the legislative branch are the majority, they are also the executive. So it's kind of one and the same. That's where we have a system in Canada where the prime minister or the premier at the provincial level really has almost, well, is it absolute power? And so if we have the courts just simply as a kind of an arm of the executive, does that raise in your mind a system where we really don't have the proper checks and balances in our democratic system?
Checks and balances is not a feature of the Westminster Constitution. Checks and balances is a Madisonian idea, and is the birthchild of the American Revolution. We have something called the fusion of powers, and both the legislative and the executive powers are fused in the office of the prime minister, for example. And that power is kind of supreme. Is supposed to be above the court, and there is a reason for it. Of course, is that courts are appointed by the crown; they are not elected. And in the evolution of this system, we infused a certain democratic ethos that we want to prevail. And so what we have is a certain kind of competition inside the fusion of powers between these institutions. And what the 1982 Constitution did was essentially tilt the field towards the courts. And the courts are now trying to grab more power to assert a kind of supremacy over the legislative. This is bad because the courts judges are appointed, judges are not elected. So if a judge goes rogue, let's say, and we can argue whether they have or not, we don't really have too many mechanisms to remove them and to remove them quickly. So the living tree is the philosophy that essentially paves the road for this kind of power grab from the courts. The classic case in Canada is Vrind versus Alberta in the late 90s,
Right.
in which the courts decides a matter of human rights, and the category of human rights that they're deciding on is not listed in the Constitution. It is clear that it's not listed in the Constitution, and we know from the legislators, several of the legislators who participated in framing the Constitution, explicitly said that right is not included in that list. So it doesn't get clearer than that. And then the court comes around and says, yeah, it's true. The legislator said that it's not included, but we must now read the Constitution as though it is there.
Wow. So what an example. Yeah.
Right. And so that is a clear example of people who, when they want to make law, they can. And again, it's not that is necessarily illegitimate. Courts can do that, but they are basically subverting the mechanisms and grabbing more power for the court than they are entitled to.
Okay, so this issue of judicial activism, I'm going to ask all three of you this question, beginning with you, Marco. Is this an issue that is going to really determine in the future the perceived legitimacy of the courts? If we don't get a hold of, well, judicial activism, I think that's what Brian's article is really saying. It's underlining, hey, there's a flag here warning us against judicial activism. Is this going to determine the perceived credibility of the institution itself, Marco, in your opinion?
Absolutely. There is a long-standing idea in the Westminster tradition that the institutions must appear to be doing things justly and correctly and ethically. So the appearance is crucial, and that appearance is slowly eroding because many of these sort of politicization and shenanigans. The other aspect, which Brian also mentioned, in addition to activism, is that judges are becoming more and more political. Witness Judge Wagner, basically poo-pooing on Canadian citizens for protesting against, the existing government, or I think, which is even worse, perhaps, is the ganging up of a bunch of judges on the Alberta Premier. Those are clear indications that judges are politicizing
Mm.
themselves. No one has invited them to do that. They're doing this on their own
Mhm.
accord. And so what is kind of interesting and ironic, of course, is also that when they do that, they fire the politicians and they think the politicians don't fire back. But
Mhm.
some of the citizens do fire back, and then they complain that people are attacking them, right? Which is kind of
Mhm.
unfair and is kind of whiny in some respects. And that also, by the way, erodes the dignity of the court.
Indeed. So, Brian Giesbrecht and Leighton Grey, Brian, are Marco's comments make a lot of sense that as judges kind of weigh in, like Judge uh, Wagner's comments about the truckers' convoy, or weighing in with different Alberta judges weighing in and critiquing comments by the Premier Smith. Are judges kind of undermining their own credibility by wading in and becoming political in that sense, Brian?
Oh, the short answer, yes. And I wrote an article, as many did, criticizing the Chief Justice's decision to not recuse himself on the very important case that's coming to this to his court now. It seems to me, in the first place, he should not have made those remarks about anarchy, etc., and alienating really half of the population of the country.
Yes.
But I think that if he had simply apologized and then agreed to recuse himself, I think that would have been the course for him to follow. Instead, I'm afraid he's made things a lot worse for his own court by the stance he's taken. That's my opinion. I'm not meaning to criticize the man individually. He's obviously a very capable, learned, qualified man, but I think he's just made a big mistake, and I think that the courts are overreaching in many respects. I remember there was Sam Friedman was a legendary Manitoba Court of Appeal justice, and he criticized one of my colleagues who had overreached, basically saying he should keep his big judicial nose out of this. And he had a way of words, and I think that the courts are going too far. But I go further than that, because I think that Canadians got a lot of things wrong in 1982, and I think that there's going to have to be. I think we're inevitably heading towards a constitutional debate. I mean, we've got referendums coming up in Quebec and possibly in Alberta, and I think at some point we are going to have to bite the bullet and start taking a look at all of these things. My pet peeve, of course, is the entire Indian apartheid system. I think we've got to find a way of getting rid of it fairly and very carefully, etc. Obviously, because there are many lives at stake. But at the same time, Canada can't go on with as an apartheid country. That's what we've been now for these years. But I also think we have to do, take a look at other things too. And I was recently, this is off topic a bit, David, but I was recently looking at old Joe Clark's old community of community idea.
Oh, yes.
And there's actually a lot to recommend that, and I think that might be kind of where we're going, where the provinces have more control. The federal government is forced to sort of hand over a little bit of control, and I think the premiers of Alberta and Saskatchewan and Ontario, for instance, have asked the federal government, I think quite reasonably, they want to have more say in who is appointed as a Section 96 judge, because after all, the the Section 96 judge is appointed federally, but deals about,
Mhm.
I don't know, Leighton 95% with provincial property and civil rights, etc. So
Mhm.
I think that the premiers are asking something making a reasonable request. We just want to have more
Mhm.
say in who's appointed, because these people are so important.
Mhm.
And I think the federal government is going to have to start um, uh, um, giving a little more control to the people at the more local level. And I think that would also greatly benefit the court itself, because then getting back to my original point, then we'd probably get some more judges who are more representative of the communities that they're serving. So,
Mhm.
but I do have this idea, which I've written about, that we are headed towards some type of constitutional debate, whether we want it or not. I think there are many things that are just unsatisfactory right now to so many
Mhm.
people, and they have to be addressed.
Okay, so Leighton Grey, what's your comment? Is there kind of a reckoning coming on these issues in your mind?
Well, I think Brian's right. Again, I wrote a piece for my show called Juristic Park, which is a play on words.
Yes.
Most people are familiar with Michael Crichton's famous novel and the movie Jurassic Park, where
Mhm.
essentially a group of scientists cannot resist the temptation because they have the actual power, the
Mhm.
technological power to create dinosaurs. And of course, they
Mhm.
do it, and things don't work out very well. And it seems like right now, metaphorically, the T-Rex roaming Canada is Aboriginal title, if you listen to Brian carefully. But the point I want to make is that this has deeper reverberations for the rest of our political structure. Brian
Mhm.
pointed out that premiers now are questioning, well, these judges are sitting in Alberta, they're applying our laws, but we don't have any say in who's appointed. And it's
Mhm.
important to note that there's been one of the other features that's happened since 1982 is an intense concentration of power in one office, and that's the prime minister's office. And of course, that
Indeed.
was never the intention.
Mhm.
That was never supposed to be part of Canadian law. That's a big problem. But it's not just the prime minister. Marco wrote, I'm going to pump his tires. He wrote a brilliant piece giving a report card on our outgoing Governor General, Mary Simon. And part of
Mhm.
what Marco said, and he can perhaps comment on this better than I can because he wrote it, but he essentially said, even the Governor General, who's supposed to be a ceremonial appointment, is behaving politically. And the way that she behaved politically actually caused damage to the country. She was appointed as an avatar for reconciliation. And
Mhm.
as Marco, he asked the rhetorical question, well, what did she reconcile? And he's quite right in his
Mhm.
assessment that we're worse off than we were before we got Mary Simon. And then here's another one. In Alberta, we have a group of Indian chiefs who represent a fraction of 1% of all Albertans, and they're
Mhm.
stopping. Most Albertans didn't vote for them.
Right.
These guys are essentially appointed by their communities,
Mhm.
and they're actually stopping a referendum that at least 700,000 Albertans want to have. And so
Unbelievable.
this idea of appointed undemocratic political power, it has deep reverberations for the whole system. It's not just the
Mhm.
judiciary.
Mhm. Indeed. I like the way our conversation is going, is because you're calling out how this has real implications on the trust, the confidence that people have in these institutions. So we got to pay attention to this. So I want to turn in the last part of this far-reaching conversation to solutions. Where do we go from here? There's a bit of a summary here, that, and this has been alluded to. So Brian Giesbrecht has noted, well, the importance of the appointment process for judges. Maybe it's about time that the provinces have a big say in the appointment of judges, as you say, Leighton, that actually make decisions about their own laws in their own province. What about the law schools? It sounds like we've got a lot of philosophy going around to the living tree. Who gave judges this much power? And what is being taught in our law schools? What about the law societies? What are they pushing? And also legislative leadership. It's often been said that when legislative bodies don't make decisions on a myriad of issues, then they create a vacuum where the courts have to go in, and that's really not necessarily fair to them. What are other ideas? Any solutions here that you'd like to emphasize, Brian Giesbrecht first, and then Marco, and then Leighton?
Well, I think in the broad context, I think there is sort of a reexamination of many of the things that have been taught in our universities now for the past couple of decades, and this whole idea of social justice and breaking people down into oppressed people and oppressors and that sort of thing. We've seen how that has just taken complete hold, even in law societies. I know, again, a little bit off topic, but Leighton would probably know Jim Heller, who stood up for the
Indeed.
basic idea that he just said, when we're referring in the learning materials, the educational materials, to the graves at Kamloops, they should at the very least put like potential graves or probable graves, and he was he was called a racist.
And maybe we could just clarify. So I believe there's a lawyer named Jim Heller who was forced to, as well as many lawyers in across Canada, the Law Society requires training to retain your license. And in those materials, it maintained in the BC curriculum, I believe it was, that it asserted that there were mass graves. And of course, Mr. Heller said, no, that's actually not true. There's nothing been found. And so on that basis, I believe there's been a conflict where Mr. Heller is now in a tussle with the BC Law Society. Is that essentially the summary of it?
He didn't, not mass graves, no. But the course material referred to graves as if it was a proven fact that there were graves there.
Indeed, yes.
And Jim Heller just made the very, very reasonable request that please take out at least put potential or probable into that. And he was called names, and his own law society really went after him. And now he has received an apology of sorts, but he had to be very brave in doing that, because not many lawyers would want to take on their profession like that. But my point is that this type of thinking has even, I would say, infected law societies, and there's something very, very wrong there. It started in the teachers' colleges, and then the faculties of social work, etc. But it really has taken hold at law schools. So I think that there is sort of a bit of a reckoning now. I don't know if the other panelists agree with me, but I think that we're starting to take a look at some of these things. Why is this happening, and why are some of the to me, outlandish things like that Jim Heller thing example occurring within our very institutions? Why did our politicians, for instance, in that, again, referring to that Kamloops graves thing, why did Justin Trudeau lower flags and kneel in a graveyard he knew had nothing to do with residential schools? Why don't our journalists start asking some tough questions and all of these things? So I think that this is starting to happen at some level, but I think a lot more has to happen, because at the present time, this whole social justice campaign, we have to start rethinking that, I believe. And I think that's very important, because it's a big part of what we're discussing here today.
I think you're absolutely right, Brian. Facts and evidence matter, and so does debate. And if you don't have debate, well, how do you get to those facts and truths? And if that is put on its head, where facts don't matter, then you can kiss Western civilization, let alone the law, goodbye. So what are your comments, Marco? What are your comments relative to solutions here?
I think Brian is correct about universities, law schools in particular. They have been a huge component of what essentially has been this great deterioration of things. But I also, before I talk about 2 or 3 solutions, I would like to say that this is not a universal problem, right? We have a former judge here that had his head properly screwed on. We had almost another judge in this program as well, who has his head properly screwed on. It's
Indeed.
not all. And the irony of what we're talking about is that two different judges, actually four different judges in two different courts, ruled that the invocation of the Emergencies Act was a power grab, and it
Yeah.
was out of constitutional bounds.
Right on.
Right.
Yes.
So there are courts that have done their proper job, and by and large, they're not all of them. So one problem is law school. So that is a solvable problem, right? Universities need to get their act together, and provincial governments need to appoint good people, better people, I would say, to their boards of governors. We need to start fostering that judges become more modest, that they are not politicians, they are simply adjudicators of justice and the law, so that they should, Judge Wagner could start by recusing himself, as Brian suggested. The appointment issue is become a bit controversial for no apparent reason, right? When the Premier of Alberta decided that she wanted to have more input in the judges that are appointed over Section 96 courts, she was accused of being anti-democratic. Which is absolute nonsense. Quebec has a very large participation in how the judges are appointed that belong to Quebec, and this is done in other federations, like in the German Federation as well, in which the sub-national level governments have a significant input. We can do that. We should exercise some intervener discipline. The court should not allow everybody and their grandmothers to come into the court and argue nonsense. And finally, and speaking about courts that are doing right, by the way, there is a court decision in New Brunswick. It's called the Walatoski. I don't know if I pronounced that correctly. That kind of runs against the grain of the Cowichan decision. So, in other words, if you own property in New Brunswick, you're okay. If you own property in BC, especially on the Lower Mainland, look out. This is part of the chaos that this kind of progressive thinking and living tree is generating. And so we should have, as a last point of the things that we ought to do, though the list is by all means not exhaustive, is entrench property rights.
Very well said. I like that summary, Marco. And I also appreciate your highlighting that there's some really great judges in our country. So let's be careful not to generalize, but there is this trend that's happening. And I think if you read the decision regarding the Emergencies Measures Act, the invocation of that was deemed illegal, I think those decisions are quite well said in my opinion. So turning to you, Leighton, what are your comments? Where should we go from here in terms of solutions?
Well, I think the other panelists have all made great suggestions, but I'm going to turn to number 5, and this is the citizen of our country.
Indeed.
G.K. Chesterton said a lot of very quotable things. One of them he said is that a civilization is not destroyed by wicked men, it's destroyed by weak men who cannot defend what is good. Well, let's ask the question, what is good? I think truth is good. And I think that part of the problem that we're suffering through in modernity or post-modernity is the loss of a connection to what is objectively true. If you look historically in our culture, in Western culture, going back to the Middle Ages, there was an objective standard that ran all the way through our law, our philosophy, or even our mathematics. And all of that is being, in sort of the post-Enlightenment era now, all that is being sort of watered down and whittled away so that, it's your truth, my truth, their truth. There has to be a truth. And
Indeed.
I think that we are a society, Canada is a civilization that's based upon a commitment to the truth. Despite what Mr. Carney says, Canada was and always has been a Christian country. In my living memory, we had something called the Lord's Day Act. There's a Genesis chapter 127 is inscribed on the Parliament buildings. That is our understanding of what the truth is. And I'm not saying that we need to have a Christian theocracy. No. I'm not saying that. I'm saying that there are principles of law and of our culture, and you're understanding that the word culture is just really a synonym for religion, that are vitally important to the way that we see ourselves and the way we behave in society. And that goes all the way down to the individual citizen and all the way up to the most powerful people in our country, to the prime minister and the governor general and Supreme Court judges and the like. And I think that we have to have a greater commitment and a greater value for what is objectively true in our country. And I think that's something that each individual person has power over. Maybe the hardest person in the world to control. I don't know if it is for you guys. For me, it's myself. I think that's universally true. So, if we can exercise, if individually we have a greater commitment to truth, I think that can go a long way to producing better families, stronger communities, and on and on and on.
Well said, Leighton. I like that you're getting at the reality that a lot of these things are symptoms of a deeper issue, and that is our belief as citizens and our culture about what truth is. And in some ways, what is being pushed as ideologies in many universities is actually quite revolutionary and quite disturbing. And that is they're switching out the epistemology of society about what is truth. And so let's be clear that we have to recognize this trend, and that does not serve citizens. So we need to speak up. And speaking up then, I'd like to ask you, Leighton, one of the comments that was made a few minutes ago was, well, shouldn't judges, instead of being appointed, should they not be elected? Do you think there's any merit to that kind of approach to how we should, frankly, get rid of the appointment system? Let's just elect our judges. Your thoughts?
Well, it's certainly a different method. And one of the things it might do is it might give more local input to judicial selection. However, if you look at the example in the United States, their judiciary is as infected with judicial activism as ours is, perhaps worse, if you're following some of the decisions that are trying to stop everything Donald Trump is doing. So that is not a silver bullet to solve the problem. I think that the solution is deeper. It's in the things that Marco and Brian are saying, and that is we've got to get in the universities. The law schools, I'm ashamed to say this, have been hothouses for some of the worst ideas that Professor Saad calls idea pathogens.
Yes.
DEI, critical theory. It's coming out of law schools, and it's really a pity that that's true, because that's something that we could change, and unfortunately our universities are places that someone like Frances Widdowson, she can't even set foot at the University of Lethbridge, let alone speak bizarre. There. That's got to change. And I think if we can change that, go back, I think we've got to go back earlier in the process in terms of who's going to law school? What are they being taught there? What type of values are they bringing into the legal profession? And what type of values are the legal profession promoting? Because I can tell you in Alberta, I took the similar course, and I probably could have got exempted from it because of my background, but I took it because I wanted to see what it was. And I can tell you it wasn't very good. It wasn't very high quality stuff. It was the kind of thing you'd get in a very, very bad grade 7 social studies class. And Brian's quite right. Oh yeah. A lot of the stuff there was quite spurious. And the worst part is, if you read the Canadian Manifesto by Conrad Black, he has such a wonderful celebration of real Canadian history in that book. I encourage people to read that. And that's the Canadian history we should be teaching people in school. That's the Canadian history we should be teaching our lawyers. And this sort of slanted, progressive version of our history, which denigrates our country, which makes us question whether we're a good people. I can't think of many countries that have less to apologize for and more to be proud of than Canada. That's Indeed. The way I feel. And I think that's what we should be teaching people in our universities and our schools.
Right on. Well, this topic has been well discussed here today. I'm very proud of our discussion. And I want to thank you, Brian Giesbrecht, for writing the paper, the analysis that you did, provoking us to think constructively about the important roles that judges play and how we get it back on track and strengthen this important institution. So thank you, Brian, and Leighton Grey, as well as Dr. Marco Navarro-Genie for this discussion today.
Thank you.
Thank you, David.
Thanks. It's been my pleasure.
So that wraps up our discussion today. To our guests, and of course, thank you to MCA Media, our producer Lorraine, and to you, our audience. It's been delightful to see all the comments come in today. Obviously, you care about this topic, and I encourage you to share and like this program. This is important, and speak up. And be sure to catch us every week on these channels, and check out our website at the Frontier Center for Public Policy. And I encourage you to have a great week as we look forward to our next program this Thursday on The Live.
Here at Frontier, we don't receive any government funding. We are nonpartisan and we work for you. Find out more and support this important work by visiting fcpp.org today.